most times when a mom who's been a stay-at-home mom and is not the breadwinner comes to you for a consultation, they generally have access to some amount of money, because a retainer in a case only needs to be, a minimum retainer for a divorce could be $5,000, especially if you know that the other side, the other party, the money spouse, if you know there's money in the case, an experienced attorney is not going to turn away a case because mom came to him and only has $5,000 for the retainer. That attorney is going to know that once the case begins, the judge is not going to let the husband, whom has the money, just roll over mom because she can't pay for it of her own money, because it's joint money. His income is joint income. The assets they have are joint assets, even though he hasn't shown her anything in years, doesn't tell her anything in years, just puts the tax return in front of her each year and she signs it and off it goes. Even though mom is in the dark, what she's going to find out at the consultation is that, she has quite a bit of money. She just doesn't know how much. So mom will probably have a credit card that she can put some money on. Maybe she borrowed some money from somebody. And that's how the case can get started. If she comes in and says, I have no money, no credit cards, nobody to borrow money from, but he makes a lot of money and we have assets, there are times I will say to her, listen, we're going to do a limited retainer where I'm going to make a motion to the court asking the judge to release X amount of dollars for your retainer and additional money for further legal fees. And if the judge grants that, then I will be your attorney. If he doesn't grant that and doesn't say that we could take money from the assets or from your husband's income for the retainer, then I can't be your attorney because I can't get paid. So that happens sometimes in cases, and when you explain to the judge the situation in the motion, many times the attorney from the other side calls up before you get to court and says, wait a minute, you don't need to make that motion. How much do you need? $10,000? Okay, they send over a check for $10,000. Because the last thing they want to do is have the case start off with the judge hearing that the guy who makes $1 million a year, they have $3 million in the bank, is not letting his wife have 10 grand to get divorced. So that's the way you handle it. And the case where the family doesn't have 10 million, doesn't have a $3 million earnings situation, but maybe the guy makes 200,000. Maybe they have 500 grand in the bank. Maybe they have 50 grand in the bank. It doesn't matter. There's money there for you to get paid. And you could make the same motion to the court. If I get my retainer from the judge, I'm in. If not, I'm released. And as I said earlier, in that case, I believe the other attorney would still call you and still send over your retainer, because I know if I were the other attorney, I would certainly do that. I don't believe we'd even get to that. I would probably have gotten a call from the other attorney, and I would have told my client he has to release $5,000 or some amount of money. And if he said to me, I'm not giving her anything, she didn't deserve anything, that's when I become the counselor again. And I say, do you want the judge to hear the very first thing about Mr. Smith or Mr. Jones is that he wouldn't give his wife $5 grand out of her money, that she has they have a $100,000 joint account, and he wouldn't give her access to her $50,000 of it? That will be the totally wrong way to start the case. And hopefully the attorneys in the case will take control of that.